Number one, is that spelled correctly? There's usually a Y-E-N.
That's what I was thinking too, but that's what they put in the hit confirmation too, I think, so.
What would do you want something?
Yes, Judge. We wanted a bond on him. I believe it's a 1997 warrant. So I'm a bit.
He's here if we want to bring
He is
him
in the
up.
back.
Please.
So I did want to see. I asked them to agree on a bond. They are not because of it's criminal history. He's got criminal history that dates 20 years back. I don't believe he's got anything current as of 10 years. So this is a warrant out of New York.
Yes.
30-year-old warrant. So
He's literally he's been on, that the warrant is truly 30 years old, really? Is that old?
1997.
Yes, Judge.
What,
Written confirmation on it would be great.
from him?
No, from I believe. I should usually have something. See if we have something.
Wow.
The judge hears the list: burglary, assault, robbery, and weapons charges from New York in the late 1990s. When cases are this old, accuracy matters more than speed.
So it's a burglary, it's an assault, it's a robbery, and a possession of a weapon. Okay, I guess let's talk to him when he comes out, you know?
1997 New York, Judge.
Is that what was happening in 97? I thought New York was dangerous, but shit. Do you want to do a name change, Katie, or no?
I don't want to
For
say
the
right off
future
bat.
case, Judge?
No.
This is spelled N-G-U-Y-N, and there's always an E.
I don't think we would need one for the fugitive case.
Okay, I don't know.
I can look at the warrant and double check.
Good morning, Ms. Nguyen.
Good morning, sir.
Mr. Nguyen, you're wanted out of the state of New York for a host of charges, specifically for a burglary, an assault, a robbery, and a possession of a weapon.
He did do parole. He was out on parole about 10 years ago on these cases. So once again, we're not sure.
Wait. That may change things. If he's out on parole, then, hold on.
I'm sorry.
It's okay. But if he's out on parole, Katie, there may be a
Everything hinges on one key issue. Was parole actually completed, or was it violated? Without that answer, the judge's hands are tied.
pre-signed waiver.
He completed parole.
Judge, let me check. I'm not seeing that we have a pre-signed waiver,
Have you?
but I think that, Amy, you had some contact with the jurisdiction?
Yeah, so Manhattan County reached out to us this morning. They were asking if we had the waiver or a refusal for him yet. They didn't indicate to me whether this was a probation or a parole. I can reach back out to them to see. Yeah,
That's really important.
I'll do that.
He couldn't have completed because there's a warrant. There would be no warrant if he completed parole.
In as much as
Something must have happened, Mr. Nguyen.
Can I say something now?
But don't talk about the case in general, but just
Can I say something?
there's a warrant for a reason.
The defendant claims language barriers and paperwork mistakes derailed his entire case years ago. He insists he served his time and followed the rules afterward.
Can I say something, please?
Of course.
I used to live in Brooklyn. I committed crime and I lose. When I'm 16, 17, I don't speak English that much, so they send to me whatever they send to me. They send me to Rock Island and they send me to upstate. And the judge say like burglary, on robbery, some kind of stuff like that. But I do not speak English that much at that time because I came United States when I'm 14. And 5 years later, I got arrested. So I basically understand a little bit, not that much. So when I go to court, they just do whatever they want to do. They don't tell me nothing. The case, they just say you got arrested, you got robbery, burglary, something like that. But I do not understand like that right now. So basically, after I finished, after they tell me that, they send me Rock Island. Or Rock Island, they send me upstate. So I do 5 years. First, I do 5 years.
Okay.
And I see the parole.
Okay.
Parole, give me 2 more years. and I finished 7 years, and I went home. And then I went home. I do first. I went to live in Long Island first, and then I still go see a parole in New York, right? And then my parents live in Houston, Texas, so I asked for transfer, my paper in transfer to Houston, Texas.
Okay.
So I've complete my parole, everything, and the opening.
What year?
No. So you may have tried to transfer it. Perhaps it never transferred and you just came down here and never
No.
finished the transfer. I don't know.
No, I'm not the people do for me. That's why I'm allowed to transfer to.
Yeah,
Maybe there's an issue with.
there has to be some kind of issue.
Yeah, that's what I'm saying.
I don't think we have enough information to do anything right now. What I need for them to do is reach out back to New York to figure out why the warrant was issued. Is it a parole violation?
I got parole violation one time. I went home, I work, and I got violation one time. I went to work and they picked me up of what's that? Angleton. I went back over there and I stand in front of the judge. The judge said, "What you do? Why you don't parole?" I said, "I'm working." So he said, "So show me your work." So I work. I bring all my paper, tag paper. I showed him. So
He's still on parole.
no. Can I say something?
Yeah. Go ahead.
He sent me to immigration. Immigration. They're coming out. I still do parole. I still finish. I have the letter opening.
Let's do this. Let's do
We need to
this.
find out more.
Yeah.
I'd like to roll it.
But no, that's true story. That's true story.
No, I get you. We just need them to.
So let's do this.
Yes, sir.
I'm going to roll it to tomorrow because it's already
Rather than guess, the judge slows everything down. The court orders prosecutors to verify exactly why this warrant still exists.
nearly 12 o'clock. I want to give them time to look into it, to see what New York has to say. A lot of times when you get on parole, you sign a document that's a pre-signed waiver, meaning that you already agreed to waive extradition if this happens. We need to know if that has happened and if you have signed that, because if you have, I cannot give you a bond. Even if I wanted to give you a bond, I cannot give you one because there's a waiver that's already been signed.
What does that mean, waive, sir?
I'll let Ms. Oko explain that to you in back because I got a lot of people waiting.
Yes, sir.
But regardless, I'm not ready to do anything today.
Yes, sir.
I need more information from the prosecutors.
Can I say last thing before I go?
Sure.
What I do is, what happened is I finish parole, everything. I get the letter from Albany, say I'm complete to Albany State in New York. That all the paper go to Albany. Albany.
But something must have happened.
Something, we need to figure it out.
Yes, I got the letter. Everything. They send me a letter. Everything.
And Judge, I would just add that, I mean, at least from what I'm seeing when I run him, which I'm a little hesitant, but like there's like multiple states with like criminal histories that's like very extensive. That's more than just New York. And so we would also have to try to like.
Okay, I guess just take your time, find out, and then we'll regroup tomorrow.
And all his things 20 years back. There's nothing more.
I get it. I just want to know if there's a pre-signed waiver. We'll see you tomorrow.
All right, thanks, sir.
Okay, of course, Mr. Wayne. Please.
The courtroom tone changes instantly as a different defendant steps forward. This time, the judge isn't dealing with paperwork confusion. It's repeated bad behavior.
Greg, how's jail?
Order in the court, please.
All we do is ask you one thing, right? Got to know that we mean business. 1, 2, 3, here we go. It's over and over and over. I mean, how do we get through to you? It's a rhetorical question you don't have to answer, but that's the nature of the beast. How do we get through to you so that you know we mean business? Because apparently in the past, it's not been enough. I get it that you may have a child coming. I get it that there are other things, but no means no. Doesn't matter what circumstance you have coming here, but no means no. Do you understand?
The judge makes it clear. Excuses don't override court orders. Life circumstances don't change the meaning of no contact.
And the problem is I know that your lawyer has negotiated something upstairs for you to see the baby in the hospital somehow, but I don't know how that can truly work out without there being some kind of I want you to see the baby, but I don't want you to see her. How can we make that happen? That's the rub, Miss Jewett, is that I'm happy to go down on this bond, but I just don't want them to be together, you know? So how do we do that?
Well, so Judge, I understand your concern, but the problem is we can't really inevitably stop two people who want to be together to be together. I mean, I get what you're saying.
We are. This is how we do it.
Well,
This is
I
how we do
understand.
it.
I understand that, Judge. But in reality, even if he doesn't get out today, and there's a conviction, whatever may come about, he'll eventually get out, and then again, we can't stop them from being together. So it's more along the lines, I guess, of kind of like the felony court said. Listen, he needs to take anger management class and complete it. He needs to stay away from her, because an ankle monitor, stay away from the home, but we're not going to stop him from seeing his child or being there with the child, which inevitably means he has to be around her for that particular purpose.
But there has to be an intermediary that's around that can help out, whether it's his mom, whether it's her mom, whether it's brother, sister, cousin. There has to be an intermediary that can facilitate. They have these apps that the family courts use that basically are an intermediary so they can communicate with each other using a third party.
A child on the way forces the court to balance safety with parental rights. The judge is trying to prevent future violence before it happens.
So there's always a way.
So we could say that his supervision, when he's with or the intermediary that will be there with the baby and him, would be either his mother or his father. So at no times would he be left alone.
I'm down. I'm okay with that. But I've told you this before, when you have cancer, what do? You cut it out or it's going to kill you. There are certain people in your life that are like that. They're just your polar opposites. Yes, you may have a happy time where both of you act like gumdrops and rainbows and, but it's not like that forever. It's going to change. And the problem is that you two together, when that change comes, it really explodes into something catastrophic. And one of you invariably ends up in jail. That's the problem. You get upset. There's a certain way to handle things. It's called maturity, right? You learn how to deal and cope with someone who makes you mad. Either you walk away, you do something else, go exercise. Somehow you have to deal with the anger. That's maturity. That's growing up, because you can't continue the way you are, because either someone's going to get really hurt or likely dead. That's it.
This isn't just legal advice. It's a blunt life lesson. The judge warns that unresolved anger plus stress can lead to irreversible consequences.
And that's why I'm scared to put you together, because not only this, but you now have a baby coming into the world. That's extremely stressful, especially when you don't have money, That's why it scares me to put you two together. But if you have an intermediary, that's meaning a third party that's willing to help you get access to the child, that's great. The only other thing I'm going to tell you is that there are certain ways for you to be able to get definitive access to that child, meaning a court order. First you establish that you're the father. After that, you get visitation and custody, so that if that other person tries to play games with you, you can either have them held in contempt, They could be jailed, fined if they start to play games. That's something else that you need to look into because it very well may happen in the future. So that way you are protected and you don't have to take matters into your own hands. Do you understand, Mr. Craig? All I'm asking you to do is grow up. It's not hard. You think before you act and you think before you speak. And when you do that, good things happen. So now, what about the bond amount, Ms. Jewett?
Well, Judge, you know my position. I'd like a $1,500 bond on each offense, which will match the $3,000 that I have already secured in the felony court.
What do you think?
Your Honor. So
Whose case is this?
it's Conrad's case. I can email Conrad if you want to get him.
Does he have a position as far as bond is concerned?
So, Judge, he told me yesterday that he would defer to you on the bond.
That would be Conrad's position, is to defer to the court.
Put that on there?
Yes.
Okay. I want you to know that I am now going to put conditions on your violation of a protective order case. The Texas Constitution does not allow me, but in very limited circumstances, to hold someone at no bond, zero bond. This is that case now. If you violate conditions on a violation of a protective order, I can have a hearing to hold you at no bond. Do you understand? I expect you to live up to these conditions. And you now have 3 open cases. If you should pick up a 4th, if you pick up, or if you violate conditions, I will have no more sympathy. Do you understand, Mr. Craig? So, this is what I'll do, Ms. Jewett. I'm going to order no drugs, no alcohol. I'll order no contact with the complaining witness in this case. I don't want him to go where she lives, where she works. You're going to have an ankle monitor on you, so I know where you are at all times. Do you understand what's expected of you? I'm not asking much. I'm just asking you, don't have contact and follow the law. Don't pick up a new case. Your lawyer is asking me, your bonds now are set at what, 20,000 on one, the other one set at 10,000 on one. She wants me to reduce it from 30,000 to 3,000. That's a big ask. Can I trust you?
Yes.
Okay, Ms. Jewett. I will acquiesce this one time, but if it goes south, I don't know what else to tell you, you know?
Judge, I completely understand. I've told my client the same thing in no uncertain words. This is it for him. And Judge, also, just so you'll know, the felony court has ordered the ankle monitor for him. So just so the court knows that that's already been ordered.
We'll tack on the same condition as well, so that if there are any violations, we will know as well. Did you hear all that?
Yes, Judge, the no drugs, no alcohol, no contact, refrain from GPS prior to.
And then no weapons? Yeah.
And just as far as the no contact, with the caveat that he can have contact, well, he can be around her with an intermediary for the birth as it relates to his children.
When is that going to happen?
Well, he already has one child that's 18 months, but the baby itself will be born in 3 weeks.
So you want access so that he can be in the same place while she's having the baby?
Correct, Judge.
And then after that, no more contact?
Correct, Judge. After that, then the grandfather can facilitate his getting the baby, whatever needs to be done.
Okay, I'll acquiesce to that for that one and sole purpose, okay? But after that, no more contact with her. Do you understand? And only if someone else is there. I don't want you alone with her on that one day. You understand? You hold the keys to the jail cell. No one else does. Go up. It's not hard. You have to do it eventually. All right? All right, make me proud.
Judge, what should you give?
Bond reduced, both. Bond reduced to 1,500 on each.
Judge, did you lower the bond?
1,500 on each. Yeah. Okay, I think we're good. All right, Ms. Jewett, I gotta get you a date. Hold on.
Judge, so one of them's an MAJ. How much time?
We'll just carry it.
Okay, how's January 28th through the 30th?
January 30th would be perfect. I'm go the misdemeanor court on the 27th.
Required appearances?
How old is the case?
199 days.
Yes, yeah.